In this presentation, my partners, Hannah, Anna, and I, will be applying what we know of the cognitive theory of memory, specifically working memory, from what we have learned in class as well as researched for this project, to eyewitness testimony. We plan to propose a way this knowledge can be applied to help fix the flaws found in eyewitness testimony today. In order to do this, it is important that we lay out some facts about eyewitness testimony and working memory. The nonprofit organization titled Innocence Project seeks to use DNA evidence to release the wrongly convicted from prisons in the United States. In their over 360 wrongful conviction cases that have been overturned due to DNA evidence, mistaken eyewitness identifications accounted for over 71% of the wrongful convictions. An article by Schmel and colleagues titled Beyond the Ken delves into the depths of eyewitness testimony and how jurors think. It was found that jurors generally have a lack of understanding of how memory works, and thus they often take eyewitness testimony with a lot of weight. The problem is, as Anna will soon tell you, most eyewitness accounts can easily be distorted by many internal and external factors, like gestures, which was studied by Gurney and colleagues. Often psychological experts aren't allowed to share in court what they find out in experiments pertaining to memory, as it is argued that it is not applicable to real life, and this was found in the Scientific American. But psychologists actually have a grand understanding of memory and what affects it. Our subsequent slide is based off of the working model proposed by Badley. Working memory is responsible for the integration of information and is largely responsible for decision making. That being said, working memory does have limitations, as it can only hold about 5 chunks of information at any given time, which leads to it needing to fill in the gaps at certain times. In 2019, Papenmere and colleagues found that individuals have a tendency to use backward inferences to complete any information they may have missed based on what they would expect to happen, even if it did not occur. This offers an explanation to Wells' findings in his 2006 experiment, where individuals observed a robbery and made up information about the robbers, leading to misidentification. Essentially, their brains made assumptions. Many individuals may not mean to do something like this, but there are many limitations to memory that we cannot control. Other studies, such as Davies, also involving robbers, demonstrated that 61% of individuals were unable to identify that the perpetrator changed halfway through the robbery. This is change blindness. Now add the fact that people that are eyewitnesses are often experiencing the stress of the incident themselves, and you have another problem. Stress induces high cortisol levels, which in turn impairs working memory and the visual spatial declarative memory performance, which has been confirmed by a digital span test in Tavernier's study in 2010. These limitations within working memory heavily influence the outcome of eyewitness accounts.
So now that we have this basis for working memory and its limitations, we can get a little bit more to the application of eyewitness testimony. So the first pioneer in this field was Elizabeth Loftus. She was first interested in researching semantic information in long-term memory, but decided she wanted to study something that held more social and applicable importance, such as how memory reconstruction affects the legal system. So this led to the famous car crash experiment by her and Palmer in 1974. We studied this in class. It was groundbreaking in regards to false memory and memory reconstruction, which hadn't really been a huge topic at the time. Based off this experiment, Loftus then created what she called the misinformation effect, which suggests that witnesses are sensitive to post-event information that can alter their perception of the original event. So for her car crash study, this would be either using the word hit or smashed, and then seeing how fast participants think the car was going, even though they were going the same speed. Loftus then furthered her work with false memories in the 90s. This was the implanted mall memory that we saw with Pickrell in 1995, and she was often called to be an expert witness in court. However, her work and trial was met with lots of resistance when she began insinuating that some repressed childhood trauma might be false memories, similar to what she had proven with the mall scenario. Regardless of the extent to which false memories play a role in court and the controversy, Loftus made it clear that memory is much more malleable and unreliable than previously thought. A large study and analysis done by Schmeckel, O'Toole, Easterly, and Loftus in 2006 aimed to prove that jurors actually know very little about eyewitness testimony and created a list of variable factors for reconstruction, which is what you see here. The first variable is accuracy confidence correlation, which just shows that a witness's stated confidence is actually a very poor indicator of accuracy, and jurors don't always know that. They take it to heart. Stress effects actually show opposite to what you might think. You might think that while a stressful situation would make things more vivid, it actually can result in difficulty recalling details such as a person's face or clothing. Time estimates isn't as large of one, it's just that witnesses typically overestimate the amount of time it took for an event to happen, but still important if you're trying to set up a timeline. Cross-race bias is we are better at identifying our own race, and so when trying to identify someone of a different race, you might make more mistakes. I know we already talked about post-event, which is same as the misinformation effect, but I think it is important to note that Gurney in 2013 indicated it's not just this verbal information that can have an influence, but even visual gestures that people subtly make when talking, such as a lawyer when questioning someone. And finally, the presentation format that witnesses are using right now of a police lineup is actually a very poor way to recognize someone, and that doing one by one would actually be more accurate. So now that we know which specific factors of eyewitness testimony can be unreliable, we can look at how to change the system.
Judging from the information we know about the abilities of the human memory, we can understand why eyewitness testimony has shown unpredictable and unreliable results. The work of the Innocence Project demands a change to the way we conduct these testimonies. The trial process as a whole would benefit from a better understanding of this information. Studies have shown that over 75,000 people per year are called to trial based on eyewitness accounts. Experts that study this subject demonstrate that without prior training in assessing eyewitness reliability, or in our argument, an educational program to instruct them on the cognitive aspects of this kind of recollection, these key actors in the criminal justice system have only their common sense intuitions as guides. Informing all members of the court, including jurors, attorneys, and judges, about how much we should be expecting from people who provide eyewitness testimony will keep the court's expectations in line with what we know from psychology. A societal program that could provide this vital information could look like an educational course that all people involved in the court proceedings are required to go through. This would be especially important for jurors to understand, so that they would be more aware of how malleable the human memory can be. This is through no fault of their own, as many of them have not been through emotional or traumatic situations that have led them to the witness stand, but it is the job of experts to use what they know to ensure justice as much as possible. Apart from just the education of jury members so that they know how much weight an eyewitness testimony deserves, attorneys should also be informed of how their questions and interactions with witnesses can tamper with their memory. Attorneys can introduce post-event information, as defined by Schmeckel and colleagues, as information that is learned after the incident that can unconsciously make its way into memory. This runs the risk that eyewitness testimony is not only made up of what the person on the stand observed, but also what they were told by others during the trial process, even though they are not aware of this shift. These psychological observations introduce the argument that psychologists should have a greater role in the trial process. Although it is not possible for a psychologist to know if a witness is giving an accurate representation of the respective incident, they can provide vital information to help improve the legal process overall. Our argument is not attempting to decrease the importance of eyewitness testimony, but to introduce the information available to help avoid false convictions. A change to the trial process itself that could help this agenda would be recommending or requiring expert psychologist testimony in all cases that are based on eyewitness testimony. This will give psychologists a role in examining aspects of the crime or legal process that could potentially hinder the accuracy of eyewitness testimony, and ensure that the cognitive knowledge of each specific case goes on record. This change, in addition to this educational program for all members of the trial, will help avoid false convictions and ensure a higher standard for the legal system.